Afternoon, everyone. My name is Fred Cullum, Chair of IOSH West of Scotland branch, and on behalf of the branch committee, I'd like to welcome you all to our branch meeting this afternoon. First meeting of our new session, and a special welcome to those who are visiting or here for the first time. Please feel free to introduce yourself using the chat icon, and later with the speakers' questions, if you put them into chat, we will do our best to pick up on all the questions as we go through. Can I remind everyone just to mute themselves as we get through this afternoon, and we will cover branch business after the presentation and question session. It gives me great pleasure this afternoon to be able to welcome Amy Anderson from BTO Solicitors. BTO Solicitors are a regular guest with our branches, and she's going to give a presentation and a legal update this afternoon, covering some of the issues such as COVID, consultation and building regulations, and some of the HSE hot topics. So can I ask you, Amy, to share your screen with us?
Nice. Hi there, everyone. I'll just share my screen. Oh. There you are. Can you all see the slideshow?
Yeah,
that's fine, Amy. Yes.
Yeah. Great. All right, so are you happy for me just to go ahead, Fred?
Yes, if you just like to run through your presentation, thanks.
Great. Thank you. Good afternoon, everyone. I'm delighted to have been invited to speak with you all today. This is actually the first presentation I've given on Zoom, so it does feel very, very weird. Do feel like I'm talking to myself, but hopefully you're all there and hopefully you can hear me okay. Now, just by way of introduction, as Fred has just said, I'm Amy Anderson. I'm a senior solicitor in the regulatory and criminal defence team at BTO Solicitors. BTO is a full service law firm, but our team in particular specialises in assisting clients who are subject to investigations by regulators. So that's the Health and Safety Executive, local authorities, SEPA, Care Inspectorate and various others. We're often instructed to deal with a client's, we're often instructed at the outset of an investigation by the HSE. And when I say HSE today, this includes reference to local authorities as well, where they are the regulator. So that's for industries such as hospitality and retail. So we assist clients through the investigation and then with any proceedings which arise from that investigation. So that could be a criminal prosecution or a fatal accident inquiry. So we see everything from the start to the conclusion. So that's just a bit about what I do and our team does at BTO. Now, the topics that I thought it would be helpful to look at today, as Fred has just mentioned, are shown on the screen there. So that's the impact of COVID on the HSE's work, a look at recent HSE statistics and their current priorities. I'll provide an update on sentencing for health and safety offences, and then I'll have a very brief look at the recent work of the Ministerial Working Group on building and fire safety. And I'll also have a brief look at the consultation on the building regulations in Scotland and England. Now, I should say that each of these topics could easily be an hour's presentation in itself, but hopefully I'll be able to give you just enough of a flavour of each and cover each in sufficient detail, just so that you have an idea as to what's happened over the past year or so and what we might look forward to over the next year. I will spend a bit more time on the update on sentencing for health and safety offences, and that's partly because there's a lot to it, but also more importantly because it's something that will be relevant to you and your clients. And I'll explain a bit about that when I come to it. And I should say, in particular, when I'm talking about sentencing, that I'm speaking to you today from a Scottish perspective, unless stated otherwise. So if you're based in England or elsewhere, then some of the procedures that I'm talking about may vary slightly. So, COVID, I think it's been the most talked about subject for the last 18 months, and that's understandable. And it's fair to say that as the regulator whose aim is to prevent workplace death, injury and ill health, the HSE have played a real key role in the coronavirus response and will continue to do so for a while yet. Coronavirus has affected the HSE's role and work in various ways. And one of the ways in which it's been affected is the number of COVID-related RIDOR reports that have been made. Now, I'm sure all of you will be aware of this, but just by way of background, under the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations 2013, employers are required to report to the relevant reporting authority any cases of disease where there is reasonable evidence to suggest that it was caused by occupational exposure. Now, in the UK as a whole, from April 2020 to August 2021, there were almost 35,000 notifications of COVID reported to the HSE and local authorities under RIDOR, including 409 death notifications. Around half of these reports were received for workers in the health and social work sector. So that's hospitals, residential homes, daycare. Around 11% were from education, 11% from administration and defence, and 6% from manufacturing. And in the 13 weeks leading up to the end of that period, 20% of those reports were from Scotland. Now, these reports have to be investigated in line with the HSE's policies and also in consultation with the Crown Office and Procurator Fiscal Service, which I'm sure most of you will know is the sole prosecuting authority in Scotland. And so the resources required for that task in terms of manpower has been and will continue to be significant. Now, another way in which the HSE's work has been affected by the COVID response is through their COVID-19 spot check programme. Now, some of you or some of your clients may have received a COVID spot check from the HSE and know what this entails. But essentially, a spot check is exactly what it says on the tin. It's a spot check by inspectors on all types of businesses to ensure that they're COVID secure for workers and the public, and to ensure that control measures that they have in place comply with the UK and the devolved government guidance. So far in the UK, almost 170,000 COVID compliance spot checks have been carried out. Now, these are continuing since restrictions were lifted, and they will continue for some time yet as we return to the new normal and COVID continues to present a risk. Now, again, in terms of the HSE's workload, the resources required to carry out these spot checks has been significant, and the impact that this has had on the HSE's ability to carry out their normal duties as a regulator has been huge. I was speaking with one inspector just recently who said that between May and December of last year, his particular team, and he couldn't speak for other teams, but his particular team did nothing other than COVID-related activities, except where there were new incidents involving a fatality where they did investigate. But other than that, it was purely COVID-related work. Now, that is huge. Because essentially what that means is that there has been a prolonged period during which certain teams within the HSE were receiving the usual steady stream of RIDOR reports, but they simply don't have enough resources to investigate. and this will have created a massive backlog of work for the HSE, and I think we'll see the effects of that for a good while to come. And I'll come on to that in a second. Now, the backlog of cases hasn't only been caused by the increase in their workload because of COVID-related duties, but also because for a prolonged period of time, the HSE were hindered in carrying out their other non-COVID and so traditional duties due to the various restrictions that were in place. Up until fairly recently, the HSE were only attending duty holders' premises to investigate the most serious incidents, so usually those resulting in a fatality. Other incidents were effectively put on hold until the HSE were able to attend duty holders' premises to investigate, and we're seeing that happening a bit more now. But there will undoubtedly have been a backlog of investigations, which, coupled with the significant volume of the HSE's COVID-related work, will be putting huge pressure on the resources of the HSE, which, let's be honest, were pretty stretched before COVID. Practically speaking, what that means is that at the very least, we'll be seeing long delays in the HSE investigating incidents, but we may also see the decision being taken not to investigate where previously they would have investigated. And obviously, if incidents aren't being investigated, enforcement action isn't being taken and companies aren't being prosecuted. Now, the knock-on effect of that could be potentially very serious, because essentially if the HSE aren't investigating and intervening in potentially serious health and safety breaches, then there could be more accidents, including more serious accidents, which could occur further down the line due to the lack of intervention from the HSE. And I have an example of that, a very sad example actually. I have a client at the moment who reported a fairly serious work at height incident through RIDDOR in February 2020 and has heard nothing from the HSE since. Now, he had thought or perhaps hoped that that meant that the HSE wouldn't be investigating, and that may well have been the case. That decision may well have been taken. But unfortunately, in this year, just recently, there was a further more serious incident involving a fatality, which involved the same health and safety breaches which had led to the first incident back at the beginning of last year. Now, it could be said that had the HSE investigated that earlier incident, then those breaches could have been identified and remedial work undertaken. But obviously that didn't happen here, and an individual has now died. So that's a really sad thought, and just one of the really serious implications of COVID generally on the country. So moving forward, on that point, moving away from the pressure on the HSE and on to these duties that employers have, I thought it would be useful to look at what the HSE will be looking for employers to do, particularly in the context of COVID as we return to the new normal. So first and foremost, it's essential, as you'll know, for employers to consider the risks posed by COVID to employees and others who are affected by the conduct of their business, such as contractors and members of the public. Employers will need to implement control measures to minimise those risks as far as is reasonably practicable, taking account of public health regulations and guidance. The HSE's website is a great resource and source of various guidance documents prepared by the HSE on matters relating to the pandemic, such as how to keep workplaces safe as the restrictions are lifted. And so if you're looking for guidance for your own or for a client's business, then the HSE's website is a great place to start in terms of working out what you have to do. And it's important to remember that employers will have to keep this risk assessment under review, and any employer with 5 or more employees will have to keep a written record of the risk assessment. But not only that, it's important to remember that employers must also consult with their workforce on health and safety matters. Now, this has always been the case. It was the case pre-COVID, and there will be industries and businesses such as construction and haulage in which this has always been done. But there will be other industries and businesses in which employees historically haven't been consulted on health and safety matters, despite the law saying that they should be, or where employees haven't had to think too much about health and safety risks in the workplace. And an example of that would be office workers. Now, those businesses will now have to ensure that they have procedures in place to ensure the workforce are consulted on health and safety matters. An example of a procedure for this would be holding monthly health and safety meetings between employee representatives and management. And I think this will be particularly important for certain types of workers, such as office workers who have been at home for so long and who may well be feeling particularly anxious about the prospect of returning to office working. Now, I mentioned the spot checks that the HSE have been carrying out, and these will continue to be carried out. I noticed in the HSE e-bulletin yesterday a reminder that the HSE will be carrying out these spot checks and inspections of all types of businesses to ensure that they're working safely to minimise the risk of exposure to COVID. The HSE made clear in that bulletin that where businesses are not managing the risks posed by COVID, they will take immediate action. And that can range from providing advice and guidance to issuing enforcement notices and stopping certain work practices until they're made safe. And where businesses fail to comply, it could lead to prosecution. And on that point, the e-bulletin referred to a recent health and safety prosecution in England of a construction contractor, which followed a spot inspection. Now, my understanding from that case was that a prohibition notice and 2 improvement notices had been issued following a COVID spot check, whereby multiple breaches, multiple health and safety breaches were identified, including breaches relating to COVID measures. At the subsequent follow-up visit, little had been done to improve working practices, so further enforcement action was taken, and ultimately this led to the company being prosecuted. Now, that's an extreme example, and I would imagine that the majority of spot checks would result in advice and guidance being given to the business only. But it's worth being aware of and noting that the HSE won't only be interested in COVID when they carry out these spot checks, but they'll also be making sure and assessing whether a duty holder is breaching any of their other health and safety obligations in any way. So moving on, putting COVID aside, I thought it would be helpful to look a bit at the usual annual HSE statistics that we see every year. They've been released for 2020 to 21, and the figures that I'll go on to discuss are for the UK as a whole. You'll see the figures on the slide there. Very sadly, 142 workers and 60 members of the public were killed in work-related incidents. As always, the industries with the most deaths were agriculture, forestry and fishing, construction and manufacturing. And again, as always, the main types of fatal accidents for workers were falls from height, people being struck by a moving vehicle or object, people being trapped by something, and contact with machinery. Now, these figures are broadly in line with previous years, and they've remained fairly flat for the last few years. In relation to work-related illnesses and injuries, again, you'll see the figures on the slides there. I just want to point out a couple of particular statistics. You'll see 1.6 million working people are currently suffering from a work-related illness. In the last year, 38.8 million working days were lost due to work-related illness and workplace injury. And £16.2 billion was the estimated cost to the economy of injuries and ill health from current working conditions. So some really stark statistics there. And so against that background, the HSE, have released their business plan for 2021 and 2022. And that obviously takes account of the critical role that the HSE will continue to play in the response to COVID-19, but it also makes clear that it will be targeting inspections on specific issues and activities. As part of this, they have split the UK's workplaces into 19 sectors based on industry type and risk profile. And for each sector, they've created a sector-specific plan identifying their priorities and the actions they propose to take. Now, as you'd expect from the figures that I've just gone over and the numbers of fatalities in particular, there are plans relating to agriculture, manufacturing and construction sectors, but also others such as quarries, utilities, waste and recycling, and fairgrounds and theme parks. So if you're interested in what the HSE may be focusing on in terms of your or your client's industry, then I would recommend that you look at the relevant sector plan, which can be found on the HSE's website. The HSE have also made clear in their business plan that there will be a sustained focus on work-related ill health, and specifically their health priorities will be occupational lung disease, musculoskeletal disorders, mental ill health and stress. And whilst that doesn't mean that other causes of ill health beyond those priorities will be ignored, they just won't be addressed on the same scale. So again, if any of these work-related illnesses are prevalent in your or your client's industries, then I would recommend that you look at the HSE's website to see what their focus will be on. Okay, so moving on, just to provide an update on sentencing for health and safety offences. Many of you will be aware that there's been a lot of discussion in recent years about sentencing by the courts for health and safety offences, and I'll get on to why that's been in a second. But just by way of background, just to explain the context here, once a company or an individual pleads guilty or is found guilty of a health and safety offence, the court imposes a sentence. So if the company or individual has been prosecuted on what's called summary complaint, which is the process that's usually used for cases which are less serious, then the maximum sentence for a company is a fine of up to £20,000, and for an individual they can be fined and or imprisoned for up to 6 months. Where a company or an individual has been prosecuted on indictment, and that's the process used for more serious cases, the court has the power to impose an unlimited fine on the company or the individual, and where there's an individual, they can also face up to 2 years imprisonment. When considering the sentence to impose, the Scottish courts have until recently had no specific codified guidance other than the guidance provided by previous courts. So there's been a body of what we call case law which has developed, which is essentially the previous court judgments, which set out what the court should take into account when sentencing a company or an individual for a health and safety offence. In February 2016, the definitive guideline for health and safety offences, corporate manslaughter, food safety and hygiene offences came into effect, and they were produced by the English Sentencing Council. So they are sentencing guidelines which are to be used by the English courts and apply to offences in England and Wales only. And what the guidelines do, as I'm sure many of you will be aware, is that they set out a step-by-step process which the court must follow when sentencing for a health and safety offence. So it sets out that the court has to look at the culpability of the offender, the level of harm risked, which is done by looking at the likelihood and seriousness of the harm caused or risked, aggravating and mitigating factors, size of the corporate offender and the financial circumstances of the offender. And once a headline sentence has been chosen by reference to quite complex tables containing various figures, the court has to take a step back and consider whether the fine is proportionate, taking account of the seriousness of the offence and the financial circumstances of the offender. The range of fines within the English sentencing guidelines is from £50 to £10 million, depending on various factors. And so, as you can imagine, this has led to far higher sentences being imposed for health and safety offences, both north and south of the border. And since these guidelines came into effect, the courts in both Scotland and England have considered their application and interpretation. And although the guidelines aren't directly applicable in Scotland, the Scottish courts have said that they should be used as a cross-check when they are considering what sentence to impose for a health and safety offence. And so essentially the Scottish court will come to a figure on its own, but with reference to the figures set out in the English sentencing guidelines. So that's what's happened up until now. But as of last week, the Scottish courts have now have their very own sentencing guidelines to follow. So at the moment, only 2 sets of sentencing guidelines in Scotland have been developed, and they apply to all sentencing for all offences. So whilst the English sentencing guidelines that I've just spoken about apply only to specific offences, including health and safety offences, we don't yet have specific health and safety guidelines in Scotland, but the guidelines do apply to all offences, so that includes health and safety offences. So the first guideline which was developed was the guideline called Principles and Purposes of Sentencing, and that was effective from the 26th of November 2018. And it sets out that the core principle of the sentencing guidelines is that sentencing in Scotland is fair and proportionate, and it sets out various ways that the court can ensure that sentencing is fair and proportionate. They also state that the purpose of sentencing in Scotland is the protection of the public, punishment, the rehabilitation of offenders, giving the offender the opportunity to make amends, and expressing disapproval of offending behaviour. The second guideline is the guideline on the sentencing process, and this is the one which came into effect just last week on the 22nd of September. It applies to all offenders who were sentenced or are sentenced on or after the 22nd of September of this year. And the guideline provides a framework for the sentencing process. It sets out a sequence of actions or steps which the courts should follow in order to reach a sentencing decision, including some of the factors which may be taken into account by the court. So I'll go through each step at the moment, and although they apply to all offences, I will look at them from the point of view of a health and safety offence. So step 1, The court is to assess the seriousness of the offence, and to do this they look at the culpability of the offender. So they'll consider, did the offender intend to cause harm? Was the offender reckless as to whether harm was caused? And they'll also look at the offender's age and level of maturity. They'll also, at this stage, look at the harm that has been caused or risk. So they'll look at the impact of the harm on any victim. And it does, as I said, include actual harm or risk of harm. And that's important for health and safety offences, because for a health and safety offence, there doesn't have to be actual harm caused. It's simply that there's been a risk of harm. And that harm could be caused to an individual, property, society, and the environment. So a huge range of harm that could be caused or risked. Factors that might be relevant here is where there have been multiple victims, or where there's been a sustained offence over a period of time. So for example, where a breach has been found to have taken place or to have been present for several weeks, months, even years, that will be taken into account at this point in sentencing. And obviously, as either or both of the culpability and harm increase, so may the seriousness of the offence, and therefore the fine to be imposed by the court. The second step is for the court to select the sentencing range, and at this point they will have regards to any applicable sentencing guidelines, and it may well be that it's at this point that the Scottish courts have regards to the English sentencing guidelines on health and safety offences. Step 3, and this is an important step, which for reasons I'll come on to later, this is where the court looks at identifies the aggravating and mitigating factors relating to the offence. Now, for health and safety offences, there are numerous aggravating factors which could potentially be present. So, for example, it could be that the offence has been committed for financial gain or with a view to profit. For example, it could be cost cutting that has led to a breach, so basically cost cutting at the expense of health and safety. The court will also look to see whether or not the company has any relevant previous convictions, particularly where they disclose a pattern of repeat or similar offending. And they'll also look at the company's health and safety record, and that will include their enforcement record. So if the company has a history of improvement notices, prohibition notices, and intervention from the HSE, then that will be seen as an aggravating factor at sentencing, even if the breach for which the enforcement notices have been issued is not the subject of the prosecution. In terms of mitigating factors, again, there are a whole host of these. These can include a prompt admission of responsibility on the part of the duty holder or the offender, cooperation with authorities such as the HSE, the police, Crown when they've been investigating. Importantly, again, for reasons I'll come on to, it's important that, well, the court will look at the safety record of the company, and so if the company hasn't had any enforcement action by the HSE and has a good safety record, then that will be taken into account by the court when considering the sentence to impose. The next step is step 4, and that is where the court determines the headline sentence. And that's the sentence which the court considers is appropriate for the offence after consideration of all of the matters that I've just outlined, but before any adjustment for which is applied over the next 3 steps, which I'll come on to. So the court can, step 5 is where the court can take account of the plea of guilty and when that guilty plea was tendered. Some of you may be aware that an offender can have up to one third discount on their sentence for tendering a plea of guilty at an early stage in proceedings. So it's at this point that the court will take that into account. Step 6 of the guideline is where the court is to consider any time spent in custody by the offender. Certainly it won't be relevant for companies because a company can't be given a custodial sentence. It may be relevant where an individual has been convicted, but it's very, very unlikely that the person would have spent any time in custody by that point. So I don't think that part of the sentencing guideline will really apply to health and safety offences. Likewise, at step 7, the court can consider ancillary orders that are being made. But again, that's unlikely to apply to any health and safety offences. So the final step set out in the guideline is step 8, where the court is to impose sentence and give reasons for that sentence. And what the guideline makes clear is that the court should always be satisfied that the overall sentence, taken together with any ancillary order to be imposed, is fair and proportionate. And certainly the resources of the offender and the effects of a fine on its business are important and will be taken account when fixing the level of any fine for a health and safety offence. So what does this all mean? Will we see any changes in light of the introduction of this guideline? The new guideline is very similar to the English sentencing guideline for health and safety offences and more or less codifies the approach that was already being taken by the Scottish courts. So it's unlikely we'll see any substantial change to the court's approach to sentencing. But what the new guideline doesn't do, crucially, is set out any figures. So it doesn't set out the range of sentences that will apply, depending on the various factors being taken into account. So the Scottish courts will still need to use the English sentencing guideline as a cross-check. So again, we may not see any substantial change to the court's approach to sentencing. But what we will see is a body of case law developing. So that's court authorities from the Scottish courts on the interpretation and the applicability of the Scottish sentencing guideline generally, and as time goes by in the context of health and safety offences. So we wait to see what the courts will say in that regard. It may well be that they take a very similar approach to that which they've done in recent years, or we may see some changes coming into effect, but we just need to wait with interest on that one. We might also see a specific guideline for health and safety offences in Scotland. Whilst one's not currently being developed, it may well be that we see that in the future, in which case the courts would stop using the English sentencing guidelines as a cross-check and refer to their own guidelines. So why is this important to you? I appreciate you may be thinking that this is all quite legalistic and only of interest to lawyers, but I think what I hope to have made clear is that how a company deals with health and safety can have a profound effect on that company for years to come. So whether that relates to an enforcement decision, previous convictions, safety records, remedying any deficiencies identified by the HSE, all of that is important when it comes to sentencing. So whilst some of this may not appear too important at the time, it could be important several years down the line. And that's particularly important, I think, when in the context of enforcement notices. So improvement notices and prohibition notices. I'm sure you'll all know that the effect of enforcement notices can be wide-ranging. The most obvious impact is financial, because the duty holder has to take remedial action or has to stop activities completely. But there can also be reputational damage, especially for more high-profile duty holders where matters may be reported in the press. So they are some of the more direct consequences to a business of enforcement action. But what I've hopefully made clear by looking at the sentencing guidelines is that previous enforcement action and a company's safety record can significantly affect the sentence being imposed for a health and safety offence. So it's really important to consider at the time when enforcement action is being taken by the HSE. It's really important to consider whether you agree with the contents of the improvement notice or the prohibition notice, or whether it should be appealed. Because essentially, if you don't agree with that a notice should have been served at the time, then you certainly don't want a court to be taking it into account when imposing a sentence for a health and safety offence. It could be potentially years down the line. Now, appealing an enforcement notice, as many of you may know, is not a straightforward matter. There are strict timescales and strict procedure to be followed. So it's important to seek legal advice about the possibility of appealing an enforcement notice or about responding to an enforcement notice as soon as it's received, to ensure that your or your client's position is protected. Okay, so just a very brief look at the Ministerial Working Group on Building and Fire Safety. I just want to have a very brief look at their recent work. Briefly, because the topics of fire and building safety, as many of you will know, are incredibly complicated, and so I couldn't possibly cover anything comprehensively in the time I have left. So I just wanted to give you a flavour of what's been going on in the realms of fire and building safety over the last year or so. Now, I'm sure most of you will know the Ministerial Working Group on Building and Fire Safety has met since June 2017 to oversee reviews of building and fire safety frameworks, regulations and guidance. The initial focus of the group was on high-rise domestic buildings following the Grenfell Tower fire. But since then, it's also considered other buildings, including housing, NHS buildings, schools and prisons. So just some examples of recent action that's been taken by the working group throughout 2021. They've introduced requirements for smoke and heat alarms to be fitted in all homes. They've reviewed fire safety standards, resulting in changes to those standards in relation to cladding and sprinkler requirements in housing, and they've published new standards which apply to the application for building warrants. So that's just a snapshot of what's been going on in the realms of fire safety in 2021. It's just something to be aware of. These new rules are very specific, and if they apply to you or to your clients' industries, then it's something to look into carefully and seek advice on if you think that they'll be relevant. Just finally, a very quick look at the consultation on building regulations in Scotland and England. As most of you will be aware, the building regulations set minimum standards applicable to new buildings and to new work to existing buildings. There is a consultation being carried out on the building regulations in both England and Scotland, and the aim of the consultation is to increase minimum energy and ventilation standards to improve energy efficiency of new buildings and new building work in line with the UK and the Scottish Government's ambitions to cut greenhouse gas emissions. In Scotland, the consultation closes on the 29th of October, and in England, the consultation closed on the 13th of April of this year. Now, again, there's a lot to be said about this. no doubt it's something that will be particularly topical in the coming months with the COP26 conference taking place next month. And in time, we should expect to see a raft of changes to the building regulations, both north and south of the border. That's all for me just now. If anyone has any questions, then I'd be happy to answer them.
Jim, can I ask you to come in? I see there's a couple of questions there, but
I will come in indeed, Fred.
thanks.
Yeah, first of all, though, Amy, thanks very much for that. A very worthwhile rattle across a whole range of subjects. You know, on behalf of everybody and on behalf of the branch, let me thank you very much. And yes, pick up on a few bits and bobs that have been coming in. First of all, sentencing. If the offender's a limited company, are the directors considered under these steps, e.g. their previous safety records? And perhaps broadening it out slightly, the position of directors in terms of prosecution. Am I right in thinking they're perhaps more in the frame than they might have been 10 years ago? Anyway, sentencing. Sentencing,
yeah. So if a company is being prosecuted, it will be the company's safety record that is looked at for the purposes of sentencing. In terms of, so I think the first question was, would the director's safety record be looked at? And no, I don't think it would be. It's the company that's being prosecuted, so it's the company's safety record that would be scrutinised in that scenario. In terms of directors, yes, they can be prosecuted where an offence, where a company has been convicted of a health and safety offence, and the Crown are of the view that the director, well, that offence has been committed with the consent, connivance or neglect of one of the directors, then the directors can be prosecuted as well as the company for the same offence. So yes, they are very much in the frame. You know, they can be looked at. We do get this quite a lot, where the Crown will initially, once a report has been made from the HSE to the Crown, and the Crown initially will say that they are looking at prosecuting both the company and the directors. What often ends up happening is that they will just prosecute the company. But certainly it has been it's been known for both the company and the directors to be prosecuted, and it is a risk.
Right. Thank you. Just a quick one from me, really. One subject we haven't touched on is the dreaded fee for intervention.
Yes.
Has it kind of all gone quiet on that front? Or actually, could fee for intervention feed back into evidence of culpability for a prosecution?
Well, a fee for intervention is, so that's charged once a notification of contravention has been issued to a company. Mm-hmm. And the notification of contravention will set out the breaches, or what the HSE think are the breaches of health and safety law. And very often thereafter, that's when you see the improvement notice or the prohibition notice. And so it won't be so much the fee for intervention that the court would be looking at, but more the health and safety breach that lies behind that. What I would say though is that if a company has paid a huge amount of money in a fee for intervention, that may well be taken into account by the court as a mitigating factor, or maybe not a mitigating factor, but it may well be taken into account when the court is looking at the financial resources of the company. And the court may adjust the sentence to take into account that a huge fee for intervention has been paid.
Right.
Jim, can I ask a question if you don't mind?
Of course you can, George.
Initially, the visits from the HSE regarding COVID would not, fee for intervention wouldn't apply. Has that changed any?
My understanding is that where a notification of a contravention is served on a company, then it's after that that the HSE can start charging a fee for intervention. So if the HSE have carried out a spot check, for example, and they haven't thereafter served a notification of contravention on the duty holder, then they won't be able to charge a fee for intervention.
Can I give you a scenario, Amy? If with the relaxation of the COVID regulation legislation in every walk of life, the Construction Leadership Council and the Scottish Operating Procedures recommends that companies take the COVID management plans into their site rules, so they become site rules. But the HSE come on and look at how it was before and after. Would they retrospectively give you anything if you breached your own site rules, but the legislation and regulations have been relaxed?
So the HSE would look at what's happening at the time when they have visited, unless, for example, a report has been made in relation to a breach previously, and the health and safety standards would be considered with regard to the relevant standards that were in place at the time of the alleged breach, or at the time that the HSE are looking at. So does that answer your question?
Yeah, and around about way, yeah, it does. It's still a minefield at the moment with COVID, right enough.
Sure.
Okay, George. Right, thanks very much. And just a couple of sort of quickies to, well, one certainly relative quickie to round off with. I think this is one from the heart. I quote, "Do you see a time where we will not have to actively manage COVID in the workplace, i.e. it might be ranked with flu and that sort of thing?"
I'm the person to answer that, I'm afraid. I don't think anyone could answer that at the moment. I think not even Chris Whitty could answer that at the moment. I don't know. It completely depends on the scientist's view going forward. And it may well be that there comes a time where, yes, it is just ranked with other, maybe less serious viruses, but as a health and safety lawyer, I'm afraid I can't touch on that.
Yeah, thanks. I think I know how she's going to reply to this. Thanks, you did. Just one final one from Alex. To quote, "How do you expect that the requirement for an appointed person for high-rise buildings will be extended for non-domestic premises too?" In other words, we're going for this appointed person for high-rise buildings. Is this the start of something that may sort of broaden out in due course?
I actually couldn't answer that specific question. It's something that I have to look into in a bit more detail. I was really just looking at the building regs as a kind of from the consultation basis, and just as a very sort of quick overview, because as I said, it's a hugely complex area of the law, and there's so much to it. So certainly I can take that question down and look into it and respond to it if you'd like me to at a later date. That's no problem at all.
Lovely, thanks. I think this is a point where we'll draw a line. Thanks very much. Just for everybody, Fred is about to, although he doesn't know yet, Fred is about to give you details of how this is going to be published in terms of the slides and the recording, because they will be available for people to refer back to, or for those folks who, as I see somebody is just coming into the waiting room and may have missed everything, sorry, but all that information will be available. And we've got 2 new messages, where are we? Fred, please remember, we will cover Q&A, branch business. Don't forget, stick around for the branch business. And much appreciated by somebody who's just had to leave. So Amy, that's enough from me. Thanks very much on behalf of the branch. Thanks a lot.
Thank you very much. Thank you.
Thank you once again, everyone, for participating and raising questions. Amy, can I ask you to stop sharing? Thank you.
Now we've got Anthony.
Yeah, we'll get back to the sort of business. It's been a while since we had a meeting. Minutes of, it was back on 27th of May, and those that were present, can someone either through chat or just raising verbally just to unmute a proposer and a seconder for the minutes of the 27th of May? Anybody from the executive was there that can propose and second?
I'll do it, Fred, thanks.
Thanks. And a seconder?
You can put me down if you like, Fred.
Thanks very much for that. Matters arising from it. The only thing I have arising from the minutes was the fact that we had a certificate of merit presentation, a virtual one, for the first time, and it was very successful. And a big thank you to all the committee and everyone engaged, including Anthony, in getting that up and running and organised, and for all the individual members who nominated non-safety people for the award. We had quite a number of awards on the evening. So certificate of merit, it's a case of watch this space for information as we move forward. But a big thank you for absolutely everyone involved in making it a success. What I want to move over now to is current vacancies. Susanna, yep, see Susanna, do you want to, I know you had a vacancy, and then we can pick up any others. We can get that recorded.
Yeah, so there will be one coming out shortly for a qualified professional. It doesn't have to be chartered. It's through the NHS, but you can probably go through Shirley Parsons. So hopefully that will be advertised in the next week or so. And looking maybe someone to relocate to Inverness, because I'm based up there now. So it's lovely scenery and what a different pace of life. So just to see if anyone's interested, and I can talk about any of the packages that are associated with it at some other point. So contact me if you can by the branch.
Thanks. Anyone that's got any vacancies, if I can ask you to email them to westofscotland@ioshNetworks.com, which is the branch email address, and we'll pick up and share that within the minutes if anyone's got any vacancies they want to make known. I see as we're going forward there that Anthony put up in the chat a link to the certificate of merit video, so that people can be able to view that if they wish to. And he's another one that's up and just appeared as an Ayrshire College are looking for health and safety, and some information in the chat, and we'll get that into the minutes as well. We move on from vacancies and look at the group reports. George, can I ask you to go over the construction?
Thanks, Chair. HSE commenced their campaign, or as it used to be called, Crackdown, on Monday the 4th of October. They are going to look at respiratory as usual, because as we know, it's high on the priority list. Obviously, they'll look at COVID management as a matter of course, working at height, traffic management, you name it, they'll look at it. This is where they're hunting packs, and they go into certain areas, and they will target every construction site from non-domestic to domestic. So, be aware and pass it on to your teams. One contractor, believe it or not, has been prosecuted for failure to comply with COVID regulations down south in England. He was given 2 bites of the cherry and didn't adhere to it. So he's been fined, or the company's been fined, I should say. And again, back down south, an excavator toppled into a trench, which had the HSE intervene because of the lack of management systems, processes and controls in place. So they had to intervene, and there'll be something coming at the back of that. A crane operative down south again, that's all seems to be down south at the moment, took not well in the cab and had to be rescued. we've also got to remember the rescue and recovery procedures also apply to operated plant, whether that's excavators, moxies, or anything else like that. So you maybe take note of that. And a company has been fined, Britcon is the name, it's on the Inquirer, £570,000 and £40,500 costs for a sheet pile coming away from an excavator and coming into contact with an individual, and he experienced very, very serious injuries. And it just goes to show that you can, people get very, very comfortable with other people, and you just need to be mindful of the distances and what have you. These are actually there, it's out in the ether. That's about all, Chair. Thank you very much.
Thanks for that, George. Susanna, can I ask you to, sorry, Kenny can ask before Susanna comes in. Kenny from the Public Services side.
Yes, thank you, Chair. I've got an opportunity to share something. Is it possible to share a document, Anthony? I'll start while you're doing this.
You should be able to now. Just change your permissions.
So thank you very much, everybody. This is my first report as the chair of the local public services group. So the build up to COP26 has already started, as you notice, with public announcements and information on how the event will be policed. This is a huge event. I realise I haven't put my video on. This is a huge event which will bring unprecedented levels of protest to Scotland. Major exercise took place in August with the 3 emergency services, along with military and others, on a joint working leadership and strategic management of the event, recognising that the Scottish legal system will need to be observed, and the Lord Advocate in Scotland has a part to play, which our colleagues in support from England and Wales may not appreciate. So some of the exercise was shown in a Police Scotland video on armed policing, and I had the pleasure of coordinating the risk assessments for that particular event. So if I can just share this, you can have a wee look at the back.
Hello, I'm Superintendent Stuart Mackey, Head of Policing for Police Scotland. An authorised firearms officer is like every other police officer.
Hey Kenny, if I can get you to stop sharing, and then if you reshare but click the share computer sound button on the window that pops up, then it'll allow us to hear it better.
Share sound, yeah.
Hello, I'm Superintendent Stuart Mackey, Head of Policing for Police Scotland. An authorised firearms officer is like every other police officer, but has additional training to protect the public. Firearms officers have a number of specialist skills ranging from enhanced first aid, conflict resolution and weapons handling, and obviously dealing with subjects who present a real threat and risk to officers or other members of the public. Authorised firearms officers are deployed across Scotland on a 24-hour basis. In general terms, they carry out routine patrols the same as any other police officer. However, when they're called upon and authorised by the control room inspector, they can then deploy to firearms and other threat to life incidents. Throughout the year, firearms officers have regular training events, but in addition to that, for COP26, we've engaged with multi-agency partners to carry out joint training exercises in advance of the deployment. During COP26, firearms officers will be deployed to carry out protection duties for world leaders, delegates who are attending it, and also the general public who will be attending in the area of the conference.
Thank you. The officers you saw in there were not all police officers. The ones that were wearing dark green were actually ambulance officers who are working in the kind of hot zone, if you like. And the other ones wearing the kind of dark maroon uniforms are actually fire officers. So it was interesting to see the 3 all working in what they call the hot zone, whereas a danger zone. So it was a very useful exercise on the day. The Public Services Group itself has been considering how we might support colleagues and the meaningful policies and procedures that may assist in reducing violence against members of staff. So the group is committed to this being a major theme of the work for the next 12 months. The first event will be a webinar on the 4th of October entitled Violence and Aggression to Staff in the Public Sector, an Organisational Approach. So there's details of that on the IOSH website, which if you're interested, please log on. It's hoped that that would start a number of specific webinars in specific organisations, and that we can provide an engaging and supportive session to include worthwhile discussion on that topic. Within Police Scotland, there is a group named Your Safety Matters, using the tagline, not part of the job, which you may have seen before. And this has been shared with members of that group so that they can actually hear the organisational approach, although the Police Scotland process is very much of a public health approach, bringing in wider organisations and looking at the causes of this and the attitudes that lead to this. So thanks very much for placing your trust in me and the group, and I'll do all I can to keep you updated on the group's activities. Thank you, Chair.
Thanks, Kenny. Can I ask Rosanna for your environmental group update?
Hi everyone, so I've now changed over to the environmental group chair. I've been on the environmental group committee now for at least 3 years. I'm very much involved with the work that they've been doing, and they've produced a survey they undertook last November. There was an article about it in the IOSH magazine. So I'll just summarise what I've put in the report, but essentially they were looking at like an introspective report of like who's actually part of the environmental management group, what type of competencies they had and what they were expecting from the group. So there were some interesting results, but unfortunately we didn't have a huge response rate. So I think that's going to be looked at and reviewed in terms of competency, and it's part of all the competency framework in deciding whether, you know, how much relevant environmental management we can introduce to all our members and how we can support that. So if you've got any ideas, have a look through the article. And that would be interesting for me to respond with. There was also a really good report released from Zero Waste Scotland on battery use in Scotland now and in the future. Very much in line with what Scotland's actually achieving. I think they're well ahead, more than England. I have an electric car and I see the progress that Scotland has made, just myself. So they were looking at research in medium-term projects, including specific electrical vehicle battery projections, how to use batteries, the battery life cycle, and essentially how we're going to recycle them in the future, because we've got such a big transformation in terms of energy resources and how we utilise those products, and we don't want to obviously be polluting by using more batteries. So we need to look at that, and they've done some really good research on recycling targets and carbon footprint declarations to discourage waste in terms of battery recycling. There's also a really interesting, I don't know if you've used the IOSH YouTube, but there's an interesting webinar on that was released on the 25th of August. The international challenge with the electrical vehicle batteries recycling process, and that goes through a lot of the different health and safety issues in relation to recycling of batteries. So I'd recommend that to have a look at. Another thing that's happening in November is the EMEC Green Hydrogen Project at the North East Scotland branch. So you can attend that, and I'll keep you posted after our next meeting in October of any other green type issues coming up. So please look at the links that I've sent on the report, and they should be on the website at some point, Fred. Yeah,
everyone. We'll be added in with the minutes that will go on the website, as will all the reports. Thanks.
Can I just ask that people do put in their queries so that I can take them to the Environmental Waste Management Group, and if you've got anything you want us to put on a webinar or any other areas that you want to look at. A lot of it is around waste management. There's a lot of articles around that, but there might be other areas in your business and you have some questions on that we could help answer. in the group. So please use the branch for that matter. Thank you.
Thanks, Susanna, for the update. We have another report. Keith Lyle was part of the rail group, and from that basis, the number of people involved in the rail industry. So I'll ask Keith just to give us an overview from his report.
Thank you, Chair. Thanks, Fred. Yeah, again, I've just joined the Railway IOSH Railway Group Committee this year, and we're keen to develop some of that engagement that I think has been lacking. So I'll run over a couple of points. The Safety Task Force, which people involved in rail will be aware of, have made some incredible safety changes through 2021. For those that don't work in rail, what we do have is lookout working, which I have done this before and briefed. I've been part of briefings to wider organisations who work in rail and construction, marine and the nuclear industry, and the reaction to them when we told them that we worked in the path of live trains going over 100 miles an hour, using red flags to take people out of the path of them, was quite astounding. But that still happened up until this year. So the result of a couple of fatalities, well, not just a couple, that were charged with improving track worker safety. So the Safety Task Force was set up with quite significant funding, and some people in the IOSH West of Scotland branch will be involved in that as part of the Scotland group. They've been tasked with improving track worker safety. So what that work is classed as is a red zone. Well, that's the old term and the more commonly used one. And a near miss in the rail industry is not the standard HSE term, it's a physical near miss with a train. So Scotland have removed that work a number of years ago based on some very close near misses. And this has now been escalated through 2021, and that lookout work, that unassisted lookout red zone working, has been removed as of the end of July. It's down to, I think, 97% of unassisted lookout work as its class have been removed at the end of July, with 2 or 3% just sort of on the way out. And as a result of that, near misses have reduced by 70%. So in terms of pure safety, in terms of performance, that's a great improvement. The competence that allowed that, the same as most industries, we have a competence framework. That lookout competence that allowed that person with a flag has now been split into 2 sections, one of which can be allowed, and some what you still class as a red zone work can be allowed, but the lookout competence on its own can be removed from the competence framework by organisations which are classed as sponsor organisations. And quite significantly, the region affected by the 2 fatalities in 2019, which you may recall, where 2 people were struck by a train, they've removed the 427 of their lookout competencies recently. That's a fairly significant change for those who work in rail will understand that change is not something that is easily taken on by rail and as in a lot of industries, but that is a quite significant change to what was a very common and accepted method of working. So some fairly significant changes in terms of pure safety performance for rail, and the Safety Task Force, as a lot of people, as I said, will be involved in the branch, is moving forward. They've got a lot of issues to deal with. Plant management, on-track plant and off-track plant management is a key one just now, where we've had significant injuries, and that is a focus, as well as a number of other ones. So some great work done. Again, this is only touching on the work they do and what's happening in rail. The IOSH Railway Group themselves, we have went through a number of changes in terms of personnel, and we absolutely understand that the engagement we should have has not been there not just due to COVID, the sort of past couple of years. And we understand that's something we need to improve upon, and it's something we're working with. The West of Scotland branch currently is 131 railway affiliated members. A lot of those will be working in rail, some potentially just an interest in it, but that's a key group I'd be keen to develop a bit of engagement with, discussion with within the West of Scotland branch, and as part of the wider discussion with the IOSH Railway Group. It's something they're keen to develop as well. We do have a Railway Group conference this year, which is purely virtual, from the 23rd to 25th of November. More details will be sent out by that. The chair of the group will send that out, and I'll publicise that on the website here once we get those details. That will look at things like the GB Rail, Grant Sharp's review. It will look at the Safety Task Force. Nick Millington from the Safety Task Force will be speaking at that event, as will many other significant people in the rail industry. And it's designed to be sort of reasonably brief presentations and open discussion on a number of topics, and that will be fully recorded, fully online, but very accessible, and that's to really to drive that improving engagement with the group. As I said, that'll be open to all members and really to generate a good debate, good discussion on the rail industry currently and on a number of topics. And as I said, I've just touched on a few of those there, but I'm happy to take lots of questions and, you know, develop the engagement certainly within our group here and as the part of the wider railway group within IOSH. But that's all. Thank you, Chair.
Thanks. I just see there is a question. It might be a quick one to answer before we.
I'm just looking at how the differences in PTS and the management structure. Good question. Give me 30 seconds to have a look at that one, Chair.
You want me to have a, you know, I'll continue on with things at the moment. I'll give you a chance if you want to come back on it. If not, what we can do is just add some comment into the report when it goes on the website, so that we can share that with everyone as well. So moving on with business, as we move forward into, and it might seem quite a distance away, 2022, but to me and from a number of others, it's round the corner. And as we look forward to 2022 and the way things are changing in IOSH, they're talking it's a blended aspect of meetings and hoping to return at some point to face-to-face meetings. The first quarter at the moment has been indicated of a pilot hybrid where we will be able to have a face-to-face meeting, and the exec have been discussing that this morning. So please watch out on information we'll share with you through Connect or on the website, and we'll share at each meeting as we go forward the remainder of this year, how plans are shaping up and what we're going to do, because we do have a outline plan of meetings and topics up until next April. So it's just giving you that heads up that hopefully not too far around the corner we can have, you know, a physical face-to-face meeting and increase and improve perhaps the networking of, you know, talking to someone next to you as opposed to, you know, feeling a bit shy to raise a conversation online. So just watch this space. The other thing that we've mentioned the website, or we mentioned the website, but also the email address. Please take a note of that email address, westofscotland@ioshnetworks.com. If you've got any comments at all towards the branch, please send something in. If you've got any ideas of what are burning topics which keep you awake at night, give us some views in the emails into the branch email, and we can kick it about as an exec to see how we fit things in to work with you and develop you know, an ever improving basis of contact with you. Our next branch meeting will be Thursday the 28th of October at 1 o'clock. The topic is relating to the installation and stumbling blocks about ISO 45001 and ISO 45003. So should be interesting to hear, you know, and anyone looking towards taking the standards forward to preempt some of the stumbling blocks and learn from that to help you to move forward in installing that within your workplaces. All it means for me then is to say big thank you to everyone for attendance this afternoon, and this, you know, for bearing with us as we went through the business as well as the presentations. All presentations, the presentation will be on the website at some point, and you'll get the information to be able to access that, and the minutes and all the reports from the various groups all go on the website. But say anything at all, please engage with us. We'd rather have a lot of things coming in than a blank, you know, email. So thank you everyone. Keep safe, keep well, and see you all in October.